Well, good afternoon to everyone. I hope you can hear me, and a very warm welcome to this healthcare seminar. My name is Chris Bright QC. I'm the head of the Clinical Negligence Group in No. 5 Chambers, and I'm delighted that so many of you could join us. To be honest, I'm pretty daunted as well. There are apparently 435 solicitors and other healthcare professionals who are logged on. If everything goes swimmingly, it's down to the professionalism of No. 5 and Erin and Amy, who are supporting us technically. If anything goes wrong, it's all the fault of Zoom, and it's nothing to do with us. I am genuinely thrilled to introduce John Coughlan QC and David Tyack QC, as they now are. They are stars of the present and of the future. Don't take my word for it. Go on to the No. 5 website and look at their individual profiles, and in particular what the directories say about them. John Coughlan was my pupil. I know I don't look that old, but I am. And he dealt with his pupils very gracefully. He didn't listen to a word that I said. He didn't learn anything from me, and he's done it all himself, and look what he's achieved. The directories describe him thus: an insightful barrister, calm, measured, formidable advocate, absolute standout barrister, can turn around any kind of case, a brilliant manner with clients, incredibly calm under pressure, and tactically astute, a tenacious approach. No one can beat him when it comes to detail. And he works for both claimants and defendants in healthcare law, and is very much in demand and sought after. Equally with David, who is a close mate of mine, as is John, and I frankly love to bits. He is absolutely remarkable. Again, don't take my word for it. Look on the No. 5 Clinical Negligence Group website, described by the directories as a very strong advocate, meticulous eye for detail, a grasp of complex areas of law and medicine, great client care skills, unflappable even in the most complex of cases, fantastically analytical and brilliant, and attention to detail, second to none, intelligent and tactically aware. So we have a comprehensive pregnancy mishaps seminar put together for you this afternoon, just to deal a little bit with the subject matter. And we know it's very sad, a very sad area of law to be dealing with. Matt Hancock, on the 30th December 2018, you can see it on the Gov UK website, announced wide-ranging new maternity plans designed to make the NHS one of the best places in the world to give birth by digitizing records, the Red Book, improving accommodation and services, and so on. And he did put in 20.5 billion funding. He said this: having a baby is one of the best moments of our lives, so I want our NHS to be the best place in the world to give birth. Now, that's a laudable aspiration, and one which we would all support, but sadly the reality, we know, is somewhat different, and that is still the case. When I started doing cerebral palsy and neonatal cases in 1990s, I actually said to people, these cases will die out. We will, once the historical cases work through, the lessons will be learned, and we will talk about these cases as being things of the past. And I'm genuinely sad to say that hasn't been the case. If you look at, for example, the research that has, say, come out of Imperial College London, if you look at the Embrace UK Confidential England and Ireland, UK and Ireland figures, I think, as John will pick up, then whichever side we're on, and whatever area of healthcare law we specialise in, these are sobering and startling figures. We should also remember the impact upon women. Easy for me to say as a man, but the terrible impact upon women of pregnancy mishaps, if I can use that catch-all term, and a very interesting article on BBC Futures in April 2019, which I saw, the effect of childbirth no one talks about, and deals with and details the very sad psychological impact of pregnancy mishaps upon women, and in fact, interestingly, how women's pain and suffering is minimized compared to that of men. Well, we all know that men are bastards anyway, but that article certainly endorsed it. So a continuing area of learning where we can all learn to improve pregnancy, maternity, and perinatal services for women in the area of healthcare law. So without further ado, I'll just say this. It's set up so that I think in the chat function, if you have technical issues, for which we apologize in advance, you can ask questions or raise issues with both Erin and Amy, who are dealing with that. In the question and answer function, we will log your questions. We'll try and deal with as many of them as possible, or David and John will deal with as many as possible and try and round that up to answer your questions. But with 400 plus of you, apologies again, that's not always going to be possible. So sit back, kick off your shoes. You're not on video, so you can play with the kitten or stroke the dog, have numerous cups of tea, and allow this fascinating healthcare seminar to unfold. John, over to you.
Chris, thanks very much. Thanks for the very kind words. I think I speak for both of us when I say it's terrific. It's really quite flattering to see so many of you here, near and far, old friends and new, and we're very grateful to you for giving up a chunk of your working day or perhaps your lunch hour. As Chris says, no cameras, so feel free to have your lunch with us as an accompaniment. And we chose this broad span of a pregnancy journey as it's one that encompasses a number of different stages, a number of phases marked by change in legal status, in dynamics of relationship, and in sources of harm, and in potential causes of action that may form along the way. We're going to be addressing you in roughly the same order as pregnancy itself progresses. I'll speak to you first on IVF, conception issues. David will then deal with cases involving traumatic injury to mother and child, congenital disability claims, and the current state of the law in relation to wrongful life. We'll then have a bit of a screen break, a few minutes to go and recharge coffee cups and batteries before returning, and I'll speak on labour, perinatal injuries. We'll both have a word to say on psychiatric claims and again on quantum issues. The very large majority of you are solicitors. I note some clinicians and students, and very welcome to you too. Apologies if we have to assume, given the breadth of topics we're covering, some level of legal knowledge and how these claims come to be put together. But I hope we'll be speaking in plain English and that it will be accessible to all. There are roughly 650,000 live births each year in the UK. Sadly, more than 250,000 miscarriages. Around 1 in every 250 births is a stillbirth, and 1 in 42 babies born alive are born with a serious birth defect. Now, a very low proportion of these cases will actually cross the path of personal injury or clinical negligence lawyers, but as we know, both numerically and in terms of value, clinical negligence claims in obstetrics dwarf those arising from any other source. The nature of the subject matter in the seminar gives a clinical negligence emphasis to the subject, but we have sought to include PI matters, traumatic injury, congenital disability, and in particular the psychiatric claims that will follow in the second half. And along the way, we'll see that there are traps for the unwary in conducting this sort of litigation on both sides. Fetus, mum, dad, baby, careful consideration at every stage on the legal dynamics. As Chris has said, any technical queries, please, in the chat box for Erin, who appears as number 5 Barristers Chambers. Any questions that you would like to ask the panelists, the Q&A box, I hope, will work, and we hope to get to those at the end. Thank you for questions sent in advance, which we'll seek to answer along the way. And lastly, I am asked to mention that there is a feedback form that will be circulated after the event, which of course you are only to complete if you have nice things to say. Off we go then with IVF. 2% of babies born in the UK are conceived with fertility assistance. Those babies, of course, face the same risks and hazards in their pregnancy journey as all the other 98%, but there's a slightly higher risk of miscarriage following IVF conception. My focus for this phase is the sort of error that occurs prior to conception, prior to implantation, and the sort of error that tends, sadly, to generate headlines such as this: woman given wrong sperm, another blunder at IVF Wales as eggs are destroyed. This is a case in which I advise that I'll return to shortly: implantation of a couple's embryo into the wrong woman, who then went on to have an abortion. And sometimes cases that produce distasteful results. As ever, be wary of a news piece or a piece of social media that starts with the words, "I'm not a bigot," because if you read the piece, you tend to draw the contrary conclusion. This is a case in which, as we'll see, the principles of property law reached a result that in most other forms of litigation, equality and diversity, human rights litigation, you might not expect to see achieved. Of course, the net goes much wider. There are often difficult consent, contractual human rights issues, usually arising in tragic circumstances, such as where somebody has had their gametes or their embryos frozen, but has died or divorced, and those consent issues that have gone all the way to the European Courts of Justice arise. My focus is on the PI Clin Neg side of things. Absent a claim for the additional costs of a baby born disabled, and David will mention the position in relation to a healthy child following IVF shortly, the value of these claims tend to be modest. But the legal complexity, the legal framework, really requires careful consideration. There are a number of overlapping regimes and some philosophical wrangling along the way. Breach of contract provision is mainly private. There will be express terms in the contract governing the standard of care, and absent those, there will be implied terms subject to the Supply of Goods and Services Act. We received a question in advance from Charlotte Measures at Medical Accident Group. Hi, Charlotte, in relation to screening sperm donors for recessive genes, and specifically the issue of whether cross-border donation to an English IVF clinic will lead to redress here. There are strict national and European guidelines in relation to screening. In fact, nearly 95% of sperm donations are judged either to be of insufficient quality or fail for medical reasons. But it's clear that not every genetic condition can properly be screened for, and each case, each apparent failure will need to be tested on its own facts. On the jurisdiction issue, again, on its own facts, but it's likely that a contract formed for provision of IVF in England and Wales will fall under the jurisdiction of English and Welsh courts. So thanks, Charlotte, for that. I take the next two together and briefly because they're similar in shape. The Human Rights Act provides remedies where domestic law does not, and as we'll see, domestic law does in these circumstances, but the right to family life is enshrined there. There are detailed consent provisions appended to the Human Fertilisation Embryology Act that might arguably create one of those defined classes of beneficiary, enabling claimants to bring actions based upon them, again, if necessary. The fourth item is placed in inverted commas for a reason. As we'll see, the very concept of what amounts to a personal injury arises here. And finally, perhaps surprisingly to the newcomer, we see reference to principles drawn from property law from the 18th century law on bailment. And proper consideration of each and all of those concepts taken together merits its own 2-hour seminar, and proper advice in each case depends on its facts. But the fairly settled view I've taken and settled on for IVF accidents, loss of eggs, loss of sperm, loss of embryos prior to implantation, is this. Gametes are property. We are told as much by the Court of Appeal in the case of Yearworth. That was a case involving the accidental destruction of frozen sperm preserved for cancer patients, a very sad case and a very interesting read. So gametes are property. On no proper analysis can it be said that once they leave the body, damage to the gametes amounts to a personal injury. But damage to one's property, again, slightly surprisingly for those of us who deal a lot with secondary victim claims, damage to one's property which gives rise to personal injury is actionable. Thinking about it, if I knock down your house with you still in it and you sustain physical injury, we rather skip this stage because you'll come straight for me on the basis that I've breached my duty of care to ensure your reasonable safety. But pure psychiatric injury, where it's so difficult to recover elsewhere, is recoverable under the principle in Tyack. This was a case in which a claimant recovered for psychiatric injury sustained in watching her house burn down following faulty central heating work, and damages awarded. One wonders if that will be decided in the same way now after everything we know about secondary victim claims. And in Yearworth, they acknowledged the oddity that creates, that damage to property might give rise to a claim, whereas witnessing damage to a loved one might not. Perhaps for that reason, they moved very swiftly in Yearworth onto principles of bailment. Bailment may be a word you've not heard since you were taught about it in your first year law degrees. When we all learned about bailment, it was mostly to do with checking one's coat into a cloakroom. But the binding ratio of Yearworth is that one's gametes are property, and when you donate your gametes, the clinic owes you the bailee's duty of care. And bailment is a contract designed to assure peace of mind. So in line with the holiday cases, distress, let alone psychiatric injury, is actionable. So that is gametes, and that is settled. What about embryos? Embryos are formed of a mixture of gametes. This was the question I had to wrestle with in advising in that case in relation to the wrongly implanted embryo. And drawing back to first principles on mixture, going back to Roman law and mixture of grain, or shipping law and mixtures of fuels and the like, property rights are not extinguished at mixture. More often than not, and almost entirely always, mixture creates co-ownership. And so when gametes are mixed, it seems at least properly arguable and seems likely that the embryo formed as a result is co-owned. Co-owned by the two donors. There are further complications, of course, if embryo is formed from an unknown donor of either egg or sperm. But for these purposes, I'll take a traditional mother and father donation case. So if the embryo comes to be lost or damaged, The right of action on the part of both co-owners remains one of bailment for all of their loss, including psychiatric injury. And I'll return to measure of damages in due course. That analysis is not settled law. There's no decided case running through it. It's not conclusive, and it's right to argue the toss. The law has a traditional distaste for exercise of property rights over human tissue. Human Tissue Act and the Theft Act make specific provision for circumstances in which property is held in human tissue, but generally, since the abolition of slavery, no property in human tissue is our starting point. And there is case law, for example, demonstrating it is not possible for a putative father to injunct his partner or his ex-partner from obtaining an abortion. That's a case called Peyton from the 1970s. So why is that? How do we reconcile it? If the co-ownership principle is established, it follows that the proprietary right must at some point disappear. There must be a landmark along the way where the legal dynamics shift. The Human Fertilization Embryology Act places a lot of stall on fertilization, and a lot of the consent provisions are tied to that point. Consent to do the various steps involved in IVF up to the point of fertilization, and then the input, certainly of the other half, seems to disappear from that point. It might be said that that's the signing away of property rights in the gametes upon mixture, in which case I'm wrong about co-ownership. More likely, in my view, is that implantation marks the change in legal status. There's some support for that in one or two family cases in relation to paternity and consent for implantation as the legal staging post past which proprietary rights dissolve. And there may even be some arguments for some later stage, say appearance of the fetus or appearance of the primitive streak, viability, but again, we run into difficulty with the abortion cases there. So if something goes wrong in the IVF process, then the aggrieved donors, the aggrieved want-to-be parents, have rights of redress, and that is the legal analysis we would apply. The legal status from implantation, in my view, untested, is that it's at that point the legal status of fetus shifts and she becomes, in law, one with her mother until delivery. So now over to David, who's going to guide us through the next stage, the next phase of pregnancy and all the risks that are presented there.
Well, thank you, John. And if anyone can't hear me, then just shout electronically. John's in charge of all the slides, so if he's not keeping up, I'll shout at him. I'm going to talk about events pre-birth which cause injury to the child or the fetus. And the question really is, who's got a claim for that? Is it the child, or is it the parents, or is it no one? And the law in this area is pretty technical, and there are some arbitrary dividing lines between what can and can't be claimed. So far as the child is concerned, the child has a claim for pre-birth injuries or occurrences, largely under the Congenital Disabilities Act, and largely under two main claims which were introduced by Section 1.2. Now, the background to those claims are that in law, a fetus is not a legal person and has got no legal right to bring any kind of action. So in the post-thalidomide era, when children had been disabled by their mums taking thalidomide in the late 50s and early 60s, the Law Commission was grappling with this problem about how children can bring a claim when they've been injured in utero or even before conception. And so in 1974, they produced a report which recommended a claim for unborn children, and that gave birth to the two main claims under Section 1.2 of the 1976 Act. And the first of those two claims is under Section 1.2a, and it's what I call preconception negligence. This is even before the baby's conceived. causing a disabled fetus. And in those circumstances, in an appropriate case, the child, when born, has got a cause of action for events that happened before he or she was even conceived. And the cause of action is defined by section 1.2a as being where there's an occurrence which has affected either parent of the child in his or her ability to have a normal, healthy child. But the condition of that is that, in effect, the child has to show that that problem arose as a result of negligence, and that's provided by section 1.3 of the 76 Act. So next slide, please, John. Thank you very much. So looking at the section 1.2a claim in a bit more detail, bearing in mind this is preconception negligence causing a disabled fetus. In 1974, the Law Commission set out a number of examples of where they thought that the child would have a claim under their proposed act. And I'll just read them out to you, bearing in mind that this is 1974. So some of these examples sound a bit archaic to modern ears. So there's an injury to mum's pelvis causing an injury to the child who's later conceived. Radiation damage to reproductive organs causing a damage to the fetus. Congenital syphilis caused by maternal blood transfusion into the child causing injury. A defective contraceptive pill causing fetal damage. Rape transmitting syphilis causing fetal injury. Conception with a man who fails to disclose syphilis causing fetal injury. A fairly grim roll call of events, I'm sure you'll agree, and some of them are quite archaic, but they were endorsed by Mrs. Justice Lambert in the case of Evie Toombs against Mitchell, which was heard in 2020, only the end of last year. There's a slight typo there. I've said the judge in Evie Toombs was Mrs. Justice Whipple. It's actually Mrs. Justice Lambert. So next slide, please. Thanks, John. Now, Evie Toombs is a case which is worth consideration because not only does it explain the section 1.2a Act or cause of action in more detail, but it also breaks new legal ground because it applies that cause of action to what were a novel set of circumstances. So I'm just looking at a question there. The facts of Evie Toombs were that Evie's mum was not told by her GP that she should take folic acid during pregnancy. And let's assume for the purpose of this discussion that that was negligent. That was certainly the assumption that the court adopted in deciding whether Evie had a cause of action. Evie was conceived when her mum was not on folic acid, and she was therefore born with spina bifida, with reasonably serious disabilities. But Evie is a remarkable young woman. She's still only 19, and she's achieved a lot already. She's an accomplished horsewoman who has overcome her disabilities. But she took the decision to sue her GP, and her argument was that but for her negligence, or but for the GP's negligence, she wouldn't have been conceived at a time when mum was off folic acid, and therefore she wouldn't have been born disabled. Now, if you think about it, the logic of what Evie was claiming, and she ran this claim under section 1.2a, was that but for the negligence, she would not have been born at all. And in the ordinary course of events, that's what we call a wrongful life claim, where the disabled child is saying, I should never have been born, and I'm suing someone for it. And that is an impermissible claim in its purest form. And that's exactly what the defendant GP argued in Evie Toombs' case. But Mrs. Justice Lambert decided that actually this wasn't a pure wrongful life claim. It was a claim under section 1.2a, and that Evie was entitled to recover. And the reason she said that was the case was because the GP's negligence caused conception when Evie's mum was folic acid deficient, and therefore that gave rise to the disability. And so in that pure sense, the negligence of the GP prevented mum and dad from giving birth to a healthy child, and that fell squarely within the Section 1.2a cause of action. And it didn't matter that the logical consequence of what Evie was saying was, had there been no negligence, I wouldn't have been born, because she had already got over the hurdle of fitting it into a Section 1.2a action. Interestingly, Mrs. Justice Lambert said that the parents may have a wrongful birth claim in their own name as well, but there are obvious advantages to Evie in her bringing her own claim. So next slide, please. Thanks, John. The second main claim, which was introduced by Section 1.2b, is what I call injury in utero of an otherwise healthy child, which gives rise to a birth where the child is born disabled. And that was introduced by Section 1.2b. And the definition of that cause of action is as follows. It's an occurrence which has affected the mother during her pregnancy or affected her or the child in the course of its birth, so that the child is born with disabilities which would not otherwise have been present. And you'll notice the rider, which I've underlined, beginning with the word "so that the child." As we'll later see, it's that rider which prevents a pure wrongful life claim being brought on behalf of the child. The other condition, of course, of Section 1.2b under Section 1.3 is that the child has to show that the in utero injury was caused by negligence. And if he or she can show that, then they've got a claim under Section 1.2b. So next slide. Thank you. So just a few examples of where a child has a cause of action under Section 1.2b. And it's by far the more common cause of action of the two causes of action under Section 1.2. So first example is where negligence has caused an RTA or another accident which causes an injury in utero. So the child has a claim there. Mum might have a claim if she's injured as well. Second example, clinical negligence causing injury or disease in utero. Third example, and perhaps the most common, is clinical negligence causing a labour or birth injury. And it's a point we often overlook, that when we bring these birth injury claims, actually they are creatures of statute. They are brought under Section 1.2b, but no one really takes the point because it's so well established. Now, in that regard, I've got a couple of questions which have been sent in advance, which I'll answer at this point. The first one is from Peter Trotman of Ross Aldrich Solicitors. And Peter asks, how would you assess damages for an early emergency C-section following an RTA with a claimant who had previously had a natural birth? Well, thank you very much for your question, Peter. Essentially, mum gets general damages for the pain and suffering of an emergency C-section. There are a couple of cases on point in Kent. That would be about £6,000. If mum's been injured independently, she has her own claim as well. And of course, if the child's been injured in utero and is born with injury, then he or she's got a claim as well. So the next question I've got is from Teresa New at Walker-Wise Solicitors. And Teresa asks, I have a client who has lost a baby due to a road traffic accident. She has a history of 3 previous miscarriages. How would causation be proven, bearing in mind client's history? Well, thank you for that question, Teresa. I think the answer is quite straightforward. You would need simply an obstetrician to say that in this case, the miscarriage was caused by the trauma and shock of the RTA, and distinguishing it from the pathologies which had caused the previous miscarriages. I'm obviously not an obstetrician, but I would suggest the obstetrician would find it easy to make a causal link in that case, because obviously there's a clear temporal link between the RTA and the birth of the, forgive me, and the miscarriage. Now, the slight challenge he might have, or she might have, is improving on a balance that miscarriage wouldn't have happened later on in the pregnancy anyway. But that should be fairly easy if they simply compare the traumatic shock of the RTA causing a miscarriage to the natural processes which caused the earlier miscarriages. And of course, if all else fails, then they can rely on material contribution. So next slide. Thanks, John.
David, just before you move on, sorry to interrupt, we have a question from Sharon Lamb, who I think is Hudgell's solicitors, if I'm right by that. And she says, does that mean if a child is born dead, there is no section 1(2)(b) claim? That's
right. And Sharon's anticipated my next, slide, but 2 actually, where I actually raised that, but it's a good question. But she's ahead of you, David, basically. Yeah. so well done, Sharon. So so the short answer is that the dead fetus, for want of a better phrase, it sounds terribly crude way of saying it, but the dead child has no claim. Okay, so just moving on then. There are a few miscellaneous points that arise in relation to Section 1(2) claims. The first is that the Act replaces any common law claims, and that's Section 4(5). For those of you who are interested, there was a case which did say in certain circumstances a fetus could have, or child could have, a right to bring an action, but that's been consigned to history. Section 1(4) says that it's a defence if either parent knew of a risk of disability at the time of conception, unless, however, the father knew and mum did not, in which case, presumably, child's got a cause of action against dad. Section 1(5), it's defence if the defendant took reasonable care, having due regard to receive professional advice. That is a simple statement of taking reasonable care, and it appears to be a statutory defence in addition to the normal common law defences which would exist to an action in negligence. Section 1(6), liability under either limb of Section 1(2) can be limited by contract, subject to the same restrictions that apply on limitations of liability for personal injury as applied to any case. And so it would be caught by the Unfair Contract Terms Act 1977, which restricts limitation on PI liability. And lastly, damages can be reduced for parental contributory negligence. Thanks, John. Now, there are some other discrete claims under the 76 Act. Section 1, capital A, subsection 1. This is very much overlaps with John's talk earlier on. There's a discrete claim by a child where a wrongful act during an IVF procedure has caused that child disability. But again, there's a similar condition that the child has to show negligence. Section 2, a woman who's driving who knows or should know she's pregnant owes the same duty to her unborn child as she does to any other passenger. And Section 3, Section 1 causes of action under the Nuclear Installations Act. Forgive me, Section 3 says that Section 1 of the 1976 Act does not affect the possibility of coexisting claims under the Nuclear Installations Act 1965, which I believe are to do with radiation damage. Next slide. Thanks, John. So on now to what I call pure wrongful life. Pure wrongful life claims in the name of the child are prohibited by the the rider in section 1.2b and by the common law case of Mackay against Essex Area Health Authority. And they were both explained by Mrs. Justice Lambert in the Evie Toombs case, which I discussed earlier on. Now, these wrongful life claims apply in situations where the child has a disability in utero which is not caused or enabled by negligence, but the pregnancy is allowed to continue as a result of some negligence. In other words, a failed sterilization or a failure to detect a disability. It's important to bear in mind that in that case, there's no negligence in causing the disability in utero. There's arguably negligence in allowing a disabled pregnancy, for want of a better phrase, to continue. Now, in that scenario of pure wrongful life, the child has no claim, but the parents may have a claim for what's called wrongful birth, which I'll deal with in a minute. So next slide, please. Thanks, John. So how can we contrast Mackay, 1982, which says no wrongful life claims for children, with Evie Toombs, 2020, where Evie was given a right to bring an action where the logical consequence of her argument was, well, I would never have been born but for the negligence. Well, in Mackay, the facts were that the claimant was born disabled because medics negligently told the claimant's mother that she was not a carrier of rubella. And had she known that, she'd have had a termination. But she didn't, so she gave birth to a disabled child. And the child brought a claim for what she said was wrongful life. In other words, I should never have been born disabled. The claim should have been, the pregnancy should have been terminated. And the Court of Appeal held that the child had no cause of action for wrongful life on policy grounds at common law. On the facts of that case, section 1.2b wasn't at that stage in force in relation to that claimant. But the Court of Appeal said that if section 1.2b did come into force, then that would prevent the child from bringing a claim for wrongful life. Next slide. Thank you. So in Evie Toombs, Mrs. Justice Lambert contrasted Evie's case with the case of Mackay. And she said that in Mackay, the injuries in utero were not caused by negligence. They were caused by a naturally occurring condition, which was rubella. The only thing that the negligence caused was the birth of an already disabled child. And the claimant's real complaint was that she should not have been born at all. And Mrs. Justice Lambert said that such an action would be barred under section 1.2b. Now, Evie Toombs, she said, was different because the negligence of the medics actually caused the disability to arise, because the negligence caused the conception at a dangerous time when mum was without folic acid. And therefore, as a direct result of the negligence, Evie acquired the disability. And she therefore had a valid claim under section 1.2a. And as I've said before, the fact that the logical consequence of her claim was then, well, but for the negligence, I would never have been born, didn't prevent her from falling into section 1.2a. And Mrs. Justice Whipple gave some helpful examples of where a child would not have a claim for wrongful life. Examples are where the parents are falsely assured that there's no risk of genetic condition and the child's conceived and she develops one. And in such a claim, there's no claim on behalf of the child because there's no claim between the advice and the development of the genetic condition. But the parents would have a claim for wrongful birth. So just moving on, John. Thank you very much. So the point that Sharon Lamb anticipated is there. A stillborn fetus has no legal identity and no claim. And however, in a situation where there is a terrible accident which causes injury to mum and causes a stillborn fetus, the fetus hasn't got a claim, but mum has, if for her injuries. Another neat point, which is surprisingly unreported in any other case than an unreported case, is this: where a mother or a father dies when the fetus is in utero, the child, when born, in an appropriate case, has a loss of dependency claim under the Fatal Accidents Act 1976. And the unreported authority for that is Hyams and West 1987. Thanks, John. So on now to wrongful birth claims. Well, I've touched on this in some detail already. This covers the very delicate situation where parents give birth to a child who...
David, sorry to interrupt. We've got one question before you move on, if I may, which is from an eminent obstetrician who's anonymous, but eminent is my word, not his. He's not signed himself off as I'm an eminent obstetrician. I wonder if a child can bring a claim against their mother for her negligence during pregnancy, for example, from deliberate excessive alcohol ingestion or drug use that causes a congenital injury.
My view is yes.
Well, that's it then. Yes. Okay. Good.
Although I'd say I haven't come across such a case reported or in practice, but I can't see why not.
I mean, I suppose the reality is that any woman who sadly is engaged in substance abuse during pregnancy, they need support, not condemnation, and they're probably they're probably not insured in any way, and so it's probably not worth pursuing. And so it's a question of education and support rather than a claim, isn't it?
Yes, and we just got another question from Catherine Leong. Hello, Catherine. That would not be a clin neg claim, and it wouldn't, but I still think it would probably be a claim under section 1(2)(b), if, as you say, Chris, mum is worth suing, which is doubtful, I'd have thought. So on to wrongful birth claims then. This covers the delicate situation where parents have given birth to a child which wasn't planned, or the parents have been deprived of the right to terminate the pregnancy. And the classic situations where this would arise are where there's been a failed sterilization or vasectomy, or where a child's been born disabled because of a failure to spot a genetic defect negligently, and therefore the parents have been deprived of the chance of terminating the child. Now, for many years, the law has grappled with the problem to which these claims give rise, which is, however unwanted the child, generally speaking, once they're born, they're much loved members of the family. So how can you quantify the loss, or how can you categorize as a loss the birth of something which is generally regarded to be miraculous and a joyous event? And so for a long time, these wrongful birth claims didn't give rise to any causes of action. And that was changed by the case of Mcfarlane in 2000 and subsequent cases, namely Rees, which was House of Lords in 2003, and Parkinson against St. James and Seacroft, 2001, which have further explained the law. Now, generally speaking, where a healthy child is born as a result of negligence, i.e. as a result of an unsuccessful vasectomy or something like that, the law says, and this is the conclusion that the House of Lords came to in Mcfarlane, that the costs of raising the unwanted child are pure economic loss, which is not recoverable in tort. And that's the way most of the law lords in Mcfarlane denied the claim. Others spoke about the problem of trying to quantify in pecuniary terms the birth of a child which is much loved. But essentially what it all boiled down to was that one cannot really claim damages for the birth of a much loved healthy child, however unwanted that pregnancy was. And that remains the law. However, in the birth of a healthy but initially unwanted child, the law does allow a few limited claims. It allows general damages for restriction on the freedom to limit the size of the family, and that's £15,000 subject to inflation. And the authority for that is Rees and Darlington, NHS Trust 2003. General damages for the pain of an unwanted pregnancy and the pain of labour, which is Mcfarlane. Other costs associated directly with the unwanted pregnancy and labour, which we'll discuss in the quantum section, but significantly no claim whatsoever for the cost of raising the healthy child. However, where the child is significantly disabled, there is a claim for the additional costs in relation to raising that child, given that child's disability. And the authority for that is Parkinson against St. James and Seacroft, NHS Trust 2001. And that was more or less approved by the House of Lords in Rees. And on that subject, I've got another question from Rees Morrison. And Rees is a student at the University of Law in Birmingham, and he's studying the BPC and the LLM at the same time. Obviously got his work cut out. And Rees asks the following. To what extent do the panelists agree or disagree with the decision of the Court of Appeal in Parkinson, particularly the entitlement to recover damages in respect of the costs of providing for a disabled child's special needs and care relating to his disability, but not to the basic costs of that child's maintenance? Well, Rees, thank you for that question, which is very useful. Obviously, as a practicing barrister, I would welcome any new cause of action that the courts see fit to decide on. So I'm all for the decision in Parkinson. But joking aside, or semi-joking aside, I say that the decision in Parkinson is sound in principle, largely because of the keen analysis that Lady Justice Hale applied to the situation. So in allowing the claim for the additional costs of a disabled child, Lady Justice Hale examined the judgments in the case of Mcfarlane. And she said that really what the law lords were talking about was a policy decision of deemed equilibrium, namely that the costs of bringing up a child, which were unwanted and occasioned by negligence, are balanced out by the joy of having one. And there's your equilibrium. Now, Lady Justice Hale said the position is different for a child who's born disabled, because although a disabled child is as much loved and as worth as much as anyone else, the fact is that the disabled child costs more to raise. And by allowing that claim, the law is simply recognizing that. And so in principle, I say the decision in Parkinson is sound. But as ever with new causes of action that the courts choose to introduce, the devil's in the detail and in applying the relevant test. And there's wiggle room over what constitutes a significant disability. And having set the new cause of action, the Court of Appeal said that has to be decided on a case-by-case basis. So if I've got any criticism of the Parkinson decision, it's that it's left things fairly vague about when a child is sufficiently disabled to give the parents a wrongful birth claim for their extra upbringing. So next slide, please, John. Thank you. Just one discrete point about wrongful birth claims. Although Mcfarlane described the claim, the wrongful birth claim of a healthy child and the cost of upbringing a healthy child as a pure economic loss claim and therefore irrecoverable in tort, they left open the position of whether or not a claim can be brought in contract. And such a situation might apply where, for example, people pay privately for a sterilisation and it fails, and they have an unwanted child that's going to cost money to raise, even if they're healthy. Now, the question is, why shouldn't that be claimable in contract? Because you can claim economic loss in contract. The question obviously wouldn't arise in an NHS situation where there's no contract at all. But in the case of B against IVF Hammersmith, 2018, it was held by the Court of Appeal that there was no upbringing claim in contract, even though it was pure economic loss, and that was a foreseeable consequence of a breach in contract. And it appears that the Court of Appeal were troubled by the same sort of policy considerations that the House of Lords were in Mcfarlane. So next slide, please, John. Thank you. So an important case about wrongful birth, which is about to be judged upon by the Supreme Court, is Khan and Meadows. And the decision, or the appeal, was heard in November of last year. And we're awaiting the decision of the Supreme Court. And it's worth looking out for, not just in terms of wrongful birth claims, but in terms of its applicability to the law of tort as a whole, because it's the first time since 1997, as far as I'm aware, that the Supreme Court has dealt with the vexed question of scope of duty of care. And the facts of Khan were that because of the defendant GP's negligence, the claimant thought that she was not a carrier of haemophilia, and she proceeded with the pregnancy. And she gave birth to a son who not only had haemophilia, but also had autism. And she brought a wrongful birth claim primarily for the extra costs of bringing up a child with autism, because it seemed that the costs of bringing up a child with autism were greater than the, if you like, haemophilia related costs. And on appeal, the Court of Appeal found that the defendant was not liable for the additional costs of bringing up a child with autism, because when he advised about the haemophilia, it was outside the scope of his duty of care to advise on autism. And so when, as a result of his negligent advice, the child was born with autism, which is a matter of pure factual causation, he's not liable for the costs of autism because that fell outside the duty of care that he assumed when he advised on haemophilia. So in other words, the Court of Appeal was saying that the GP is not the guarantor against all pregnancy risks just because he assumes the risk of advising on haemophilia. And in coming to that conclusion, the Court of Appeal applied the well-known principle in South Australia Asset Management Corp against York Montague Limited, 1997, which is a Privy Council case where there's a well-known quote from Lord Hoffman about an example about a mountaineer going mountaineering on a doctor's advice with a dodgy knee. And it well illustrates the scope of duty of care principle. That principle is also known as the SAMCO principle for short. And the Supreme Court has been deliberating that principle, as I say, at the end of last year. And we await that judgment, which will be interesting and of wide application. So next slide, please, John. And I think this is our final slide before our break. A few miscellaneous claims about, or points about wrongful birth claims. A disabled mother has no claim for the additional costs of caring for a healthy child, even though because of her disability, the costs of raising the healthy child are going to be greater. And that's entirely understandable, and I can see the principle behind that. And that's the case of Rees. Now, a wrongful birth claim has a 3-year limitation period, even insofar as it relates to the cost of raising a disabled child. And even though the House of Lords in Mcfarlane described that kind of claim as pure economic loss, in the case of Godfrey, it was decided that the wrongful birth cost of upbringing disabled child claim is an extension of personal injury, so a 3-year limitation applies. The additional cost of upbringing a disabled child is not restricted by what the mum's means would have been to raise the disabled child in any event. And that's the case of Roberts against Bro Taff Health Authority. And what that simply means is that if mum has a claim for the cost of raising a disabled child, she's entitled to the reasonable cost of that. It's not limited to what she would have been able to afford given her own means in any event. Father does not have to be a party to a wrongful birth claim, but it's a good idea if he is, because he might have, in a case where there's a cost of raising a disabled child claim, a longer life expectancy than mum. And further, if mum dies, dad can't be joined in after the event, and that's the case of Whitehead and Searle. So I think that's everything for the first half, John. So we can leave it there, and I think we're returning in 10 minutes. Over the break, we've been discussing that very pertinent question that the obstetrician asked, and actually I want to revise my answer. I don't think mum has a claim. As John pointed out, under section 1.3 of the Act in 1976, the child only has a claim if the parents would have a claim for breach of duty. And so if mum's been drinking and taking drugs or whatever during pregnancy, she can't sue herself for that. So I think on reflection, the answer is no. Fetus does not have a claim for fetal alcohol syndrome. So thanks to John for pointing that out. While we're on the subject, I'll just deal with 2 other questions that have been raised. The first is another one from Sharon Lamb, which is, does Mcfarlane apply if the couple never want a child in the first place, i.e. no enjoyment? Well, I think that the case certainly does apply, because the essence of Mcfarlane is that couples are entitled to damages, or albeit limited damages, for unwanted pregnancies. And if they never wanted children, then that falls within the definition. I don't think the law distinguishes between degrees of how much you don't want children. I think if you don't want them and it's unwanted, you get a claim. And there's one other question from Edward Duckworth, which is wrongful birth. What is your view as up to what age of the disabled child can the extra costs arising from the disability be recovered for? I've discussed this with John as well, and we're both very much of the view that the claim is for the parents' benefit for as long as they live. And if the child deceases, dies before the parents do, then the claim ends. So in a wrongful birth case, you would have to get a life expectancy evidence as to how long the child's going to live for. I can see another comment popping up, but I'm not sure that's a question, so I'll hand over to John. So thanks, John.
Thanks, David. We'll crack on given the time. Now we come to the sharp end. We're on to labour. Leading gynaecologist of the time, Sir Norman Jeffcoat, wrote in The Lancet in 1961 that it still remains true that the most dangerous journey made by any individual is through the 4 inches of the birth canal. Not much has changed on that front, although I seem to remember a trip to the toilet roll aisle at Sainsbury's this time last year came close. And whilst care has improved over the decades, and as Chris touched on at the start, the problem persists. Transparency has improved, record keeping. As a result, our understanding of what the standard of reasonable care during labour should look like. Just pausing there for a moment. When you compare obstetrics to many of the other areas that we deal with day to day in clinical negligence practice, it's striking how many factors that we lawyers might regard as litigation red flags are present. Much of this care is provided out of hours. Some of it is performed, God forbid, at home rather than in hospital. And there is an overlap of disciplines, many staffing issues. At the critical end of the timeline, midwifery and obstetrics often overlap between shifts within those disciplines, and overlap can mean gaps and potential for conflict and confusion and disagreement. The most senior member of the team, the most experienced member of the team, who's rarely a consultant, is not usually present at delivery, and the staff are operating under great pressures, often exhausted, often looking after several expectant mothers at the same time. And of course, the biggest decisions often need to be taken in an instant. And patient factors. This is not the calm of a GP room. This is not a hospital consulting suite, nor is the patient being kept stable by an anaesthetist in a calm and controlled environment. A labouring mother might fairly describe herself as not being entirely in full command of her faculties, be it through pain relief, through exhaustion, through distress. And yet she is being asked fully to engage and participate in the most difficult experience of her life, and sometimes to make critical decisions in the heat of a moment. So that's a heady mix of factors. And when the potential gravity of the injury is mixed in, it's unsurprising perhaps that litigation results. We will all have different levels of experience and intuition and understanding when forming an early judgment as to whether a case has reasonable prospects, viewed from either side. Ultimately, will of course be guided by the expert evidence. We thought it would be helpful in a broad umbrella talk such as this, simply to remind you of the range of injuries, the type of injuries we can expect to see as a result of labour gone wrong, and some of the practical tools that are there and the assets we have in investigating, presenting, defending claims. So in terms of investigative tools, on both sides you have access to your witnesses, to contemporaneous records, and to experts. Needless to say, the better the quality of the witness evidence you can obtain in the early stages of an investigation, the better the case can be presented. Look to the documents generated after the event. Complaints and responses often contain important early near contemporaneous accounts and information. Serious incident report investigations, root cause analyses often hold firm pointers, albeit not conclusive, on liability. Diane Lyall of Jacopi Palmer asked us to consider the impact of two fairly recent developments. Firstly, HSIBs, that's reports from the Healthcare Safety Investigations Branch, which was set up in 2018, and also whether we perceive that NHS Resolution's early notification scheme has increased the number of early liability admissions. For my part, I think it's difficult to say on either of those. Mainly by the time a case reaches counsel, those early steps have already taken place. But equally importantly, perhaps it's difficult to differentiate that from general duty of candour improvements, which have been made in the last few years, and other transparency advances. So those factors tend to have faded into the background by the time we come to a post-expert evidence liability consultation with counsel or the quantification side of the case. The HSIB question, though, is one worth asking at the outset, because if it generates documents, then those are documents you'll want to see. So thank you for the questions. And before turning to the types of injuries that mother and fetus, mother and baby may sustain, a quick word on consent. Montgomery is an obstetrics case, albeit an antenatal failure to counsel in relation to mode of delivery. Consent weaves through every stage of pregnancy. So when one thinks to investigations at the early stage and the parental right to accept or decline investigations, consent weaves through into labour, but at this point, it's important to keep consent issues realistic. I'm pleased we do have clinicians online today, because most of us have never worked on a labour suite, have very little feeling for what proper consent looks like in the agony of whatever moment it might be. Some of us have been there as punters and will be terrified having to think about the consent issues and how a clinician can grapple with consent properly in those circumstances. But because it's in the agony of the moment on the ground, it's likely to be viewed by courts in a manner sympathetic to those clinicians whilst preserving the fundamentals of consent. So here is the very broad list of risks and potential injuries to baby: stillbirth and failure to survive, even if born alive, to discharge. And as anyone who has had to explain the bereavement damages regime to grieving parents will know, either for stillbirth or for neonatal death, these are the saddest cases, because there simply is very little redress in those circumstances, but that's a matter for Parliament. Where the child survives, as we know, the bulk of litigation arises in relation to cerebral palsy. There's a long list of potential antenatal failures that David touched on earlier that can contribute to and culminate in damage. At this stage, 70% of the value of maternity claims arise from failures in CTG interpretation and consequent failure to expedite delivery. Malpresentation, disproportion, cord complications, failures to take blood samples, to accelerate at the right time, to classify them properly for caesarean urgency, to expedite and execute trials of operative delivery. All of those, of course, might contribute to the outcome. And as an aside, in relation to CTGs, there are enormous resources out there to non-clinicians, to us lawyers, on how to read a CTG, what the guidelines have to say about them, and a proper set of tools to enable us as lawyers to understand and, where necessary, challenge expert evidence in these cases and early in these cases. Moving down the list, perhaps less severe, but still very significant in terms of injury. In relation to brachial plexus injury, shoulder dystocia, the law looks fairly well settled on shoulder dystocia. But posterior shoulder cases are likely to founder and anterior shoulder cases to succeed. Although claimant lawyers amongst you, you may still have to plough that furrow of maternal propulsion versus good quality evidence on traction before you win that case. And on down, baby may of course suffer crushing injury caused by forceps, or more minor injuries, markings and caesarean scars, malposition, forceps, and the like. Not forgetting, of course, that successful delivery doesn't mark the end necessarily of the risk period for baby. Postpartum management and failures to provide proper respiratory support, to identify and manage hypoglycemia, to treat emerging infection. All of these are capable of causing the very serious injuries that cross our paths. As to mum, again, sadly, there'll be a proportion of fatal cases. Eclampsia, anaesthetic accident, undetected or uncontrollable hemorrhage. Where in a non-fatal case, there is a postpartum hemorrhage that can result in needs for hysterectomy or wider implications such as Sheehan's, life-changing pituitary damage. And in the hours that follow a successful labour, sadly, mum can sometimes be overlooked and go into urinary retention, end up with a neurogenic bladder. Commonly, we see, of course, cases of poorly performed episiotomies, vaginal tearing, failures in repairs, wrong classification as to the extent of the tear, and these often result in long-lasting damage, including urinary and fecal incontinence and fistulae, and effects on fertility. So from physical injury, we now want to shift our focus to psychiatric injury. And David's going to say a few words on primary victims.
Thanks, John. So primary and secondary victims, it's instructive to remind us of what the law says about the two categories and how it differentiates between them. Primary victims are the victims of the vast majority of personal injury and clinical negligence events. They are the people who are actually injured as a result of negligence. And if they happen to suffer psychiatric injury as well, then there is no problem whatsoever in them claiming both for their physical and psychiatric injuries. Secondary victims are people who are not involved in the actual accident and are not physically injured in the actual accident. They are people who have witnessed the accident or its aftermath. And if the circumstances are sufficiently horrific, then they may suffer psychiatric fallout, especially if their loved one is involved in the accident, and it's their loved one that they're seeing injured and in distress. Now, the law of secondary victims is potentially relevant in the sort of cases that we're discussing today, where a third party has witnessed the suffering of another. So that could be dad witnessing the suffering of mum in labour, concern for the well-being of his newborn child. And secondary victim considerations are, or at least have been considered, in the context of mums who are in the process of labour and are worrying about the health and safety of their child. And I'll come on to that situation in a moment. But before we embark on the discussion, or John does, don't expect just solutions in all cases of secondary victim claims. As Lord Stayne said in White and Chief Constable of South Yorkshire, which was 1999, not 1990, the law of secondary victims is, quote, a patchwork quilt of distinctions which are difficult to justify, unquote. And it's hardly surprising that Lord Stayne said that, because it will be remembered that White is the second Hillsborough case that got to the House of Lords. The first one was the case of Alcock in 1991, which is regarded as the modern foundation of the law of secondary victims. And in Alcock, not a single person whose loved one died in Hillsborough was able to recover anything for the psychiatric fallout of what they witnessed. And that included loved ones who were in the stadium, who knew that their loved ones were in the pen at the Leppings Lane end where it was all happening. That included people who went to the temporary morgue after the tragedy unfolded and saw their loved ones lying laid out dead. None of them recovered a penny for what they went through. And yet, 9 years later or 8 years later in White, the police who were on the scene were able to recover for the PTSD that they suffered for what they went through. And so it's hardly surprising that Lord Stayne felt compelled to point out that this is indeed a patchwork quilt of distinctions. So just moving on, John, to the next slide. I'm going to deal with the easy bit first. The easy bit is that where mum is involved in a distressing event in and around pregnancy and labour, and is concerned for the safety of her baby and witnesses or experiences distress about how the baby's developing during labour, she can claim for everything because she's a primary victim, because until the child is born, she and the child are one. So that gets rid of any complicated secondary victim issues when the claim is mum's psychiatric distress as a result of what's happened during labour. And the authority for that is YAH against Medway NHS Foundation Trust 2019. And That's the easy bit, and I'll leave it to John to deal with the difficult bit. Thanks, John.
Thanks, David. Just before I do, Sharon's asked a question about the early notification scheme. I think, Sharon, that you've partly answered the question in your second clause. Where documents are generated and they would ordinarily be disclosable, then of course there is an impact. But I'm not sure the timing of the scheme really widens the ambit of what would be disclosable in any event. And I can sense our defendant attendees today bristling at the suggestion that you should have easy access to anything between NHS resolution and the trust client. But I hope that answers that question. And as David says, secondary victim claims generally, it's been a tough time since the 80s. Of all the areas we've discussed today, this is the widest, perhaps the most controversial in any form of a PI or Clin Neg law. We want to take a specific look at the secondary victim in pregnancy, given where we are on the talk. Usually as a result, about always as a result of tragic events at the sharp end during delivery or in the immediate hours beforehand. And for a long period, we have to go a bit wider before we come back to pregnancy, but for a long period, the vast majority of decided cases in secondary victim cases have failed. There's a 2-year period, you'll see those first 4 decisions in the mid-20 teens, where the door was being pressed even more firmly shut. It's a mix of first instance High Court decisions and appeal decisions. The most potent, we'll just run through them quickly, is Taylor, a personal injury case in which it was found that the fatal pulmonary embolism, medically caused by, but separated from the accident at work by about 3 weeks, could not constitute the, open inverted commas, relevant event for the purposes of the proximity requirement, the proximity in time and space control criterion laid down by their lordships in Alcock. The daughter, Claimant, who sustained psychiatric injury at point of death, who wasn't present at the accident, therefore failed to recover. And since then, pretty much every secondary victim case and every secondary victim piece of correspondence has contained a reference, I think, to Taylor and de novo. But it needs to be properly understood. And these cases that follow have actually developed what Taylor means to a substantial degree. In shorter, Taylor was applied in a Clin Neg context. The claimant was with her sister when she died of a hemorrhage. The negligence had occurred a week earlier when an aneurysm had gone unnoticed. Mrs. Justice Swift found herself unable to conclude that the 2 events could properly be described as the claimant sought to argue, as a single event or a seamless tale, going back to Walters and Glamorgan. And so proximity not satisfied, Taylor applied. Similarly, in Ronayne, a misplaced stitch during a hysterectomy perforated the deceased's bowel. Her husband watched her suffer and die over the course of about 36 hours. As a result, somewhat surprisingly, he succeeded at first instance, but the Court of Appeal found the judge wrong on 2 counts. One, the judge was wrong to characterise the original stitch as the relevant event, and thus wrong to characterise the whole 36 hours that followed as a seamless tale and all constituting the relevant event. And secondly, it's worth reading because this is an unhelpful case on the shocking and horrific control criterion. You'll all recall that the impact must be an assault on the senses. It must shock and horrify. It must be akin to seeing a loved one mown down. And this is an unhelpful case because here we have Court of Appeal authority, unhelpful for claimants, per Lord Justice Tomlinson, who says, in hospital, one must expect to see patients connected to machines and drips. As counsel for the defendant put it, expect to see things one may not like to see. A visitor to a hospital is necessarily, to a certain degree, conditioned as to what to expect. And in the ordinary way, it's also likely due warning will be given by medical staff of an impending encounter likely to prove more than ordinarily distressing. So if your secondary victim claim arises from hospital care, That is a hurdle that needs to be confronted. I'm going to give Wild a bit more attention because it is a pregnancy case and it touches on all of those points too before we come to the what appears to be a hint of a fight back for claimants in secondary victim cases. In Wild, the failures were in relation to noting and recording babies' intrauterine growth about 10 days prior to delivery. At some point in those 10 days, baby died. That was admitted to be negligent. Mother's claim was settled. It was agreed that baby would have been born alive, but for the negligence. They were both present at that antenatal appointment to the extent that one has to be present at the breach of duty. Mr. Wild was at work when his wife called him saying she was going into hospital with some spotting and some low back pain. In his evidence, he described himself as terrified, excited about being a father for the first time, and he was present when the trainee midwife couldn't find a heartbeat. She went to find a senior who couldn't find one either. There was a procession of clinicians who came and went, and the claimant's evidence was he didn't realise what was happening at first, but there was a dawning realisation that there was a problem. And that problem grew, that realisation grew with each person that was called, and the fifth, the most senior person, having listened and had a look, uttered the words, "I concur." And the claimant said the words "I concur" were like a slap in the face for him. He described himself, I think in fairness to the claimant solicitors in that case, they did the very best they could to reflect the horror of that moment in the evidence he gave, describing himself as numb, devastated, shocked, bemused, dumbfounded, a feeling of utter devastation. And there were very distressing scenes that then followed, including Mrs. Wild attempting to leave the hospital, hearing the cries of other newborn babies, and of course, the unspeakable experience of labouring a stillbirth. It was agreed the claimant sustained definite traumatic psychiatric injury. There's a slight difference in diagnostic labels, but it mattered not. And counsel for the claimant in that case, she's appeared already, albeit converted to Mrs. Justice Lambert, was Philippa Whipple, now Mrs. Justice Whipple. She appeared for the claimant. Charlie Baggott, Queen's Counsel, appeared for the defendant, as is the norm in secondary victim cases. And the judge was Michael Kent. The defendant took the Taylor point on proximity. The claimant wasn't helped by having shifted his position earlier in the pleadings, initially filing a reply saying 10 days was a seamless tale and a single event, but later pinning his colours to the mast of the words "I concur" being the shocking event and the relevant event, marking the realisation that baby Matthew had died. It's important to know from Wild that the defendant made the submission that a father can never succeed in a stillbirth case because there's no primary victim. I happen to know that that remains Charlie Baggott's view. So we'll no doubt hear more again in future. But the court rejected that submission, holding, as David's just explained, that fetus and mother together are a single entity until point of birth, and it's too broad simply to say a stillbirth can never ground a secondary victim claim. But the court found that the claimant's problem in this case was that by the time the relevant event started, that is Matthew's death, and the relevant event being Mr. Wild's realisation of what had happened, Matthew had already died. So it's not a Taylor point. The court declined to deal with Taylor, effectively saying the claimant's got a bigger problem in this case, a new problem. Matthew had died, the injury to him was complete, the cause of action was complete, even if one characterises it as an injury to mum, because they're a single legal personality, the damage is done and the cause of action is complete. And the relevant event for the purposes of secondary victim claims is the damage, the death of the fetus, and not his realisation. So Wild and the analysis given to it, which is a sound analysis and requires tackling rather than simply distinguishing on the facts or railing against presents a real problem in stillbirth cases. It leaves open many unanswered questions. Should recovery really depend on whether a heartbeat is heard or not, whether the baby's still alive? Should the judicial inquiry extend to when the fetus sustained injury incompatible with life, and thus the cause of action was complete even if a heartbeat still was heard? Is the situation different for twins? When one heartbeat is lost, but shock, horror, distress remains and concern for the viability of the other, or even for mother? How does the overlay of mum's single legal personality with her fetus or fetuses really play into the facts of the case that you're looking at when held against the facts of Wild? So it remains a really opaque area. It remains an area in which cases continue to fail or aren't brought for that reason. But interesting context for the more promising sounds coming from the courts in the more recent raft of cases, both of which are coming to the Court of Appeal soon. In Paul, the gap between the breach of duty and the deceased's heart attack, witnessed by his children, the claimants, two of them, was 14 months. And Master Cook allowed the defendant's application to strike that out on a simple application of Taylor. In a very elegant and comprehensive judgment, Mr. Justice Chamberlain analysed all of those cases and everything that's gone before. So it's a very helpful guide to where we are in secondary victim cases, but developed in doing so a much clearer understanding of where we are generally. And it wasn't contended to him, and he would have rejected the argument anyway, that delay between the tortious event and the damaging event is the relevant delay. He said that's entirely by the by. The relevant event is when the actionable damage becomes manifest. And it became manifest for Mr. Paul when he collapsed with a heart attack. And the claimants were present for that, and the master was wrong to strike these cases out. He goes on, again another warning, to make some discouraging but slightly obiter, or certainly strictly obiter, noises in relation to the shocking and horrific criterion. He almost does so as a sop to a floodgates submission made by the defendant. But a few aside saying where cases happen in hospital, that's going to be an even steeper hurdle for a claimant to surmount. And that was followed swiftly in the case of Polmere, where our very own Henry Pitchers, Queen's Counsel, appears for the claimants. He's with us today, so he'll no doubt tell me when I get this wrong. But the trust in that case admitted its failure to diagnose a little girl's life-threatening condition 6 months before her collapse. During those 6 months, she had no extreme episodes to suggest injury, but her symptoms had continued, breathlessness and the like, and then tragically collapsed and died in front of her parents. Master Cook, again, found for the claimants on this occasion. He found the little girl as a primary victim, could have brought a claim for the symptoms suffered during those 6 months. So the cause of action was complete to that extent, but went on to find that prior actionable damage, what's called a stopping point in Paul, is not a bar to recovery. And the subsequent qualifying shocking event met all of the control criteria, caused the damage complained of, and refused the application to strike the case out. So the bullet points for secondary victims in pregnancy, again moving on because of time. See whether Wild can be distinguished on its facts, but have particular heed to timing of death, to shocking, traumatic and horrifying, and keep an eye on the decision in the conjoined appeals of Paul and Polmere. David, over to you to deal with some quantum stuff.
Yes, so thanks, John. I'm mindful of the time, so I'll rattle through this. I've dealt with a lot of it already. Neither John nor I are going to talk about the big quantum issues that arise out of catastrophic birth injuries. That could take many talks worth of discussion. We're going to focus really on the particular quantum issues that apply to the slightly more technical claims that we've been discussing today. So just going back to my wrongful birth cases, the potential claims are as follows. General damages for restriction on freedom to limit size of family. As I say, that's £15,000 subject to inflation. General damages for the pain, etc., of pregnancy and labour. That's about £9,750 according to the JC guidelines. Obviously, that will vary according to circumstances and how traumatic it all is. And the following pregnancy-related claims are supported by various speeches in Mcfarlane. Medical expenses associated with pregnancy, care and nursing costs in relation to pregnancy if mum needs some extra help because she's got morning sickness or whatever. Clothes related to pregnancy, things like maternity wear, loss of earnings caused by pregnancy and recovery from labour, though clearly not loss of earnings caused by the cost of raising a healthy child, and possibly the cost of the layette, something I wasn't aware of. Apparently, the blanket surrounding the baby is called a layette. I certainly wasn't aware of it when my turn came. And other equipment associated with a newborn baby, such as cots and what have you. If the child is born healthy, that is it. And so these are modest claims. But of course, in addition, if it's a disabled child, then the extra costs of raising the disabled child can be claimed, and they can be very, very significant, obviously, if the child is significantly disabled. But in that regard, care evidence is essential. So, John.
Thanks, David. People are asking on the chat whether this is being recorded. It is. It should be available for release when all the editing and so on is done. So if we do run over 2 o'clock by a few minutes, apologies. Feel free to leave if you have to. But the recording will be available. We'll carry on. Issues particular to pregnancy we want to deal with in this quantum section. There remains this rather odd general damages claim for loss of bringing the pregnancy to a satisfactory conclusion, with all the awkwardness of that language and the case of Bagley. This is plainly the common law circumventing the iniquity of bereavement damages not being available in a stillbirth. And that is usually the measure of the award as well. There is a case in Kemp called Kirby, which doubts Bagley, but that also comes from the 1980s and doesn't seem to have been followed much since. It is rarely an attractive argument for a defendant to pick that there shouldn't be such a common law award. And naturally, if there is diagnosable psychiatric injury to mother, then a blended award or some top-up will be appropriate under the guidelines. On general damages more widely, as far as mum's concerned, there's likely to be an association with some form of injury described in the guidelines, be it physical, such as an effect on continence or fertility. And bracket 6F of the guidelines is actually fairly nuanced as to specific issues arising in this sort of case, such as was there a requirement to abort a fetus, sterilisation, ectopic pregnancy, and the like. Leah Kelsey from DAC Beechcroft asked us in advance to consider cases of delayed diagnosis of premature menopause. In a delay case, of course, it's all about considering the avoidable symptoms during the period of delay, together with any longer-term harm caused as a result. And advanced menopause is something to consider in any case where the claimant loses her natural hormone provision. We're dealing specifically to pregnancy-related cases, so I'm not going to deal with any earlier medical failures to diagnose, but I hope that's helpful. And in pregnancy-related cases, there's likely to be, again, an associated injury, such as requirement for hysterectomy or total abdominal clearance, or some delay in diagnosis of cancer or avoidable traumatic injury to the organs, for which consult the guidelines. but never understate or overlook the menopause point, carrying as it does a requirement for hormone replacement and perhaps later life osteoporotic risk, likely to enhance general damages, possibly to bring with it a provisional damages element too. What about general damages for loss of an embryo? Picking up from where I was earlier. That's a really difficult question because property damage is usually measured in rectification or value of property lost at the time. That's what happens when you crash your car. And what is the value to be put on a frozen embryo that you've never seen? If it's property, who knows? It seems counterintuitive to apply PI guidelines where we are expressly told it's not a personal injury, but that's an option. It generally brings a psychiatric injury into play as well. And it's tempting to argue, picking up on what David was just saying, that there should be a Mcfarlane type award for loss of autonomy, loss of one's ability to plan one's own fertility and have the family that one wants. That would be a good fit. There was an attempt in 2017, I've not put it here, but the case is Shaw and Kovac, to introduce an award for loss of autonomy in any sort of consent case, which was quickly quashed by the Court of Appeal, who said that's going to take something from Parliament to do, or the Supreme Court. They contended there for £50,000 for failure to obtain consent in a surgical case. I think that would be overcooking it in any event by comparison to Mcfarlane. And £10,000 to £15,000 without serious psychiatric injury seems to be the right bracket for loss of an embryo in the cases that I have been involved in. There's a wrinkle. Where fertility replacement damages are awarded, then general damages will come down. And the authority for that is XX, a case we'll look at shortly on surrogacy. But in the Court of Appeal, Lady Justice Nicola Davis reduced £160,000 for infertility, and it was a cancer case. It included menopause and radiation damage, to £150,000, because the point of awarding surrogacy damages in that case was, and fertility replacement damages generally, was to help restore the claimant to where she should have been but for the negligence, and to the extent special damages and damages for future loss were able to do that, then that element of general damages was diminished. And that brings us finally to two strands of fertility replacement damages. Firstly, IVF. NHS provision is free. It's variable though. It's variable in eligibility criteria, availability. Even if eligible and available, the waiting list is long. Clinical commissioning groups often add their own local additional criteria in relation to weight, smoking, number of children already, ovarian reserve, and even NHS provision can cost for facilities. For those reasons, the Law Reform Act will always bite. There will always be private provision in the cases that are brought. But NHS and NICE guidelines remain relevant in terms of quantification. Every case is going to require bespoke expert evidence on availability and cost, but the HFEA suggests a private cycle should cost between £4,000 and £8,000. Additional costs, perhaps if sperm injections are required or require to be retrieved, storage, scans, and the like. And how one presents an IVF case presents a bit of a philosophical problem. What is desired is not IVF itself, but a live birth. If it's a lost embryo, then further IVF, if it's straightforward, does put the claimant back into that position, albeit with a different embryo. And who's to say that embryo has a better or worse chance of failure than what's been lost? Conception, pregnancy, live birth are far from guaranteed, either pre-negligence or in the casting the claim forward frame, and it will take significant moulding to the facts of your claim as to how it's properly presented. NICE recommends 3 cycles for the best chance of conception. In 2015, Smith et al. Looked at this, and if there's a link there if you want to dig into the data, because there's lots in it. If your expert doesn't provide you with cumulative live birth rate, ask him or her to do so, because that information is there and can be drawn from that research. So it's legitimate, I think, to present a case simply saying 3 or 4 or 5 cycles to replace what's been lost, depending on the facts of the case. The case law is fairly thin on it. Cases tend to settle. What case law there is, Biles and Riggs, suggests 3 cycles. In the bottom case there, that's an interesting case because fertility was lost, fertility was not lost, but damages for loss of fertility were nonetheless awarded. The claimant had been pregnant at the date of a road traffic accident, which sadly caused a miscarriage. She was no longer, at that point, with the baby's father. In the 5 years since the accident, she had not had any further relationships, citing her depression, social isolation, and want of money. And again, Mrs. Justice Whipple accepted those reasons and accepted that in those 5 years her fertility had reduced, and that rendered it reasonable to award 3 cycles, again, of IVF. And finally, surrogacy. You'll all know there have been changes since last year. Non-commercial surrogacy is and has always been lawful, but unenforceable and still costly. In the UK, commercial surrogacy arrangements are unlawful under the Surrogacy Arrangements Act 1985. It's a criminal offence to advertise for a surrogate or offer oneself as a surrogate. But actually commissioning a non-commercial surrogacy through an agency, and there are 3 non-profit making agencies in the UK, is and remains lawful. Pregnancy-related expenses in those cases are recoverable, and they tend to even out at around £12,000–15,000 at the outset. But then if, as is advisable, solicitors become involved on the family side of the case, parental order, specialist wills, HFEA consents, all of that, then the cost can quickly fly up into the £30,000–40,000 mark. That's the UK position. There are significant drawbacks to making a UK claim. Under all of the agencies that I mentioned, those 3, it's the surrogate who chooses the parents. So that loss of control is important to some want-to-be parents, and they have no control over it. And until a parental order is obtained, until baby is born and the family law proceedings are complete, the surrogate mother is the legal mother of any child born, and she can refuse to hand baby over. She can change her mind at any time, and parents have no redress until the parental order is granted. So it's understandable, or perhaps hardly surprising, that litigants have looked elsewhere for a more secure route for surrogacy, usually to California because it's well developed, and that was the case in XX, where the Supreme Court, in Baroness Hale's last ever case, reversed her own decision in the case of Bryody, which had held that public policy prevented recovery of damages on the basis of commercial surrogacy abroad. She frankly said, I was wrong at the time, and I'm even more wrong, or I would have been even more wrong now. Public views have changed, and it is not unlawful here to have surrogacy. We have different rules on commercial surrogacy, but public policy doesn't prevent you, the claimants, going to somewhere where commercial surrogacy is lawful. And there were 2 dissenters in that case saying there needs to be uniformity between the criminal law and the precepts of civil law. So if it's unlawful here, you shouldn't recover damages, but the majority had it. Recovery is still subject to the limits of reasonableness as to amount, but also as to expectation. So if the donor egg or sperm has so remote a chance of achieving a pregnancy, the award will be refused. That was the case in Bryody. something like a 1% prospect of a successful conception. The welfare of the child is given paramount importance. There must be proof in the evidence of adequate safeguarding if damages are to be recovered. And XX was expressly a case involving own eggs. It was the claimant's own eggs. She had 8 of them frozen. She also brought a claim for donor eggs as required, and that was approved for commercial surrogacy abroad. But there's not yet any decision or judicial consideration of double donor cases. So if both the egg and the sperm require donation, it seems instinctively more problematic to recover in a surrogacy claim where there is no genetic link to the baby whatsoever. So again, there's a bit of an open thread there. XX doesn't hold all the answers, and no doubt we will have further litigation on it. So unless Dave, you want to come back and add anything in, I think that brings us to the end today. We have a question from Nicola Fahy that, Dave, is to do with wrongful birth.
Yes, thanks, Nicola. I've noted your question with interest. It's in wrongful birth cases, what is your view on the argument that any mum will want to ensure that their disabled child is provided for after their death, and therefore the argument that we should be able to recover for care, etc., until child's death rather than mum's, dad's life expectancy? Well, unless I'm wrong, I don't think that's been decided in any case, although I'm happy to be corrected on that. But since I've seen your question, Nicola, I've been pondering it. And I think there's a very good argument for the proposition that in a wrongful birth case involving a disabled child and the need to provide for that disabled child in terms of care, which wouldn't otherwise have arisen had the child not been disabled, that there's a valid claim for putting money aside, providing for the child's ongoing care once mum and dad are no longer around. And I think if there is an argument to that effect, then it derives firstly from first principles of Parkinson, and secondly, perhaps from the case of Robertson Bro Taff, which I mentioned earlier on, where it was said that the cost or the claim for providing for the child should not be limited to mum's means. So if the argument was from the defendant, well, you wouldn't put money aside when you died, had the child not been disabled and had you not bought the claim because you can't afford it, so you can't claim it now, that would be met, I suspect, with the principle in Robertson Bro Taff. So I say, yes, it's a good argument, but unless I'm mistaken, it hasn't been tested by anyone, a judge in any case that's been reported. And I can see another question from Joy, which I think John might want to answer.
Right, there's some level of complexity there, Joy. I would need to break that down. There's a claim for a failure to freeze sperm, presumably prior to treatment of some sort, and later that was taken away from him. However, they had already conceived with the donor. It's difficult to see, other than the property damage aspect to it and any associated psychiatric injury caused by that property damage, where that takes you, because the facts have moved on. Effectively, child's been born, albeit with donor sperm. There may well be, on those facts, if I've understood them right, a modest claim for the failure to deal with sperm generally, but if in fact it was a failure to obtain it, free sperm, then I'm probably wrong about that because there was no property to damage. So it sounds to me, Joy, that would be a struggle, but obviously we'd be happy to look at that further on the facts of each case. And a couple of other comments. Thank you very much. Chris, do you want to come back?
Yeah, can I just thank John and David from all of us for a remarkable, comprehensive tour de force on pregnancy mishaps. We're particularly grateful for, firstly, all the hard work that that obviously took and you both put into it. And I'm not sure who was Chris Whitty and who was Jonathan Van Tam, but just be assured that neither of you looked like and reminded us of Boris at any time. The succinct way that you put at times very complex matters, and the skillful way, if I may say so, in which you've managed to answer questions as we went along. And really, it's a tremendously valuable resource for everybody going forward. Now, just to say, everybody, I know some people have to leave us and have already, but the link to the PowerPoint slides is in the chat. Do feel free to share that with colleagues. We're happy for you to do that. Obviously, sing John and David's praises when you do. We're hopeful that a recording to accompany that those slides will be posted to you in due course. And thanks really to everybody who's busy to have joined us from all over the country. If you'll indulge us for a moment, number 5 is a national set. We're in fact the biggest barristers set in the country. We have a countrywide reach wherever you're joining us from, not just because of our offices in Birmingham and Bristol and London and Leicester, but because we very much adopt the attitude of have instructions, have brief, will travel. If that is, of course, we're ever allowed to see each other face to face again. And in addition, the Silks and the Juniors operate a digital open door policy, if we can put it like that, to our preferred solicitors. We aim to build relationships. We aim to be accessible at all times so that you can email us throughout the life of a case and ask this, ask that, without the clunkiness of formal instructions at any stage of a claim. And finally, just to say that as the healthcare silks in chambers, all of us, we're all very happy to and keen to be involved in screening CP, neonatal, other significant cases at an early stage, to recommend experts, to discuss issues, to look at tactics going forward, and that's for both sides, of course, knowing that we won't see the case again for a number of years, but in the quiet expectation that we will eventually, because that's the deal, of course, if you want to use this as a screening resource early on. So please do remember that and consider an approach to any of us, and Henry, Jonathan, the other healthcare silks at any time. So thank you again to John and to David, absolutely fantastic, and goodbye to you all. Thanks very much indeed for joining us.